Egan Holmes, case number 12CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Mr. King, Ms. Brady, Ms. Nelson, Ms. Hicks, and Ms. Spengler. And the people are represented by Mr. Brockler, Mr. Orman, Ms. Pearson, Ms. Stitch McGuire, and Mr. Edson. And we are outside the presence of the jury. Yesterday, at the end of the day, I think, Ms. Brady, you said you wanted to talk about scheduling, and I think the day before, the prosecution had asked for some information with respect to scheduling so that they could plan ahead. And Ms. Spengler and Ms. Nelson were here and said that they would have to check with the rest of their colleagues before we could have a discussion about scheduling. So, Ms. Brady?
Your Honor, we also were trying to figure out when to start bringing sentencing witnesses in if we get to a sentencing trial. And I was looking at the calendar trying to predict, and the court is aware, it's difficult to predict when a sentencing trial might begin. But I thought maybe this would be a good time to tell the court our thoughts, and if the prosecution thinks we're way off, or the court does, I would prefer to know now as opposed to later. But I'm predicting that we will probably finish our presentation of evidence around July 7th or 8th.
Okay.
And then I don't know how much rebuttal the prosecution intends to present, but I had given a day for rebuttal, approximately a day for closings, and then the start of deliberation. And then, as the court knows, it's impossible to predict how long the jury will deliberate, but my thought was to have sentencing witnesses ready to begin on the 15th. And I was hoping the court could let me know if that sounds reasonable. I don't want there to be a delay, but I also don't want to bring out-of-state people in and have them here for a week waiting. So my thought is the 15th.
How long do the people think their rebuttal case will last? And it's hard to gauge because the defense has not finished its case, but...
Your Honor just hit the nail on the head because we haven't heard the evidence, but my anticipation at this point is a day or two maybe. So I think that, looking at the calendar, I think the 8th is like a Thursday or a Wednesday. So the 9th, which I guess would be when we would present rebuttal, or maybe late on the 8th, would be, I guess that means we would be done with evidence most likely that Thursday or Friday of that week. And I don't know when if the court, we're going to need to spend a little more time finalizing jury instructions and so forth. And I don't know how long the court, I don't remember if we've even discussed how long the court wants to give us for closing arguments for each side. So
we haven't talked about it yet.
It seems to me that we could certainly, plan on being able to get to closing arguments either on that Friday or the following Monday. On a case like this, I'm not really sure how great it is to do closing arguments on a Friday and then say to the jury, oh, you're going home for the weekend, come back on Monday and deliberate. It's always possible to do that. So it seems to me Ms. Brady's schedule makes some sense. I don't know how long a jury on a case like this is going to want to deliberate. If they want to look at all the evidence, it's extremely voluminous. Just going through that could take days. If they want to look at, I could see a jury in a case like this wanting to say, we want to look at all of the statements from Dr. Reed. That would take a whole week, if they wanted to look at all of that. So deliberations could be extremely lengthy, is what I'm saying. They could be short. I don't know. I don't have any particular disagreement with the outline of a schedule that Ms. Brady suggested. And I guess one thing I would like to ask is, it's possible that the defense will go quicker than they think, who knows. If so, I would like to tell at least Dr. Resnick, look, we're talking about the 8th or the 9th, and make sure that we can start scheduling that for him. If that's okay with the court, we can depend upon those days. If it goes longer, I guess we'll just have to deal with that.
Okay, Mr. King?
Judge, in terms of when our merits case presentation will end, I can tell you that it's going to at least occupy the 6th, Monday the 6th, and a significant part, if not all, of the 7th, I would guess. Whether that would run into the 8th is possible, but that's kind of the iffy part, depending on how long the cross-examinations and the redirect examinations are. But I fully think that we'll be done either by the close of business on the 7th or certainly on the 8th, and I think that's fairly reliable.
All right. In light of that, then, why don't we plan to have closing arguments on the 13th, which is on Monday? Is everybody okay with that?
Yes, sir. I talked with Mr. Brockler briefly about this yesterday,
Yeah.
and I don't want to speak for him, but I don't think either one of us wants much more than 2 hours, frankly. And so I was suggesting maybe 2.5 hours or 2 hours and 15 minutes or something like that, and that would be my suggestion.
I was thinking 2 hours, and I'm doing you a favor. If I give you 3 hours, you're going to take 3 hours. If I give you no limits, you're going to go on forever. I'm doing you a favor.
Me? Me?
Not you personally. You. When I say you, I mean all of you who are lawyers. That's just the way lawyers are. And I'm not being critical of the lawyers in this case specifically. I've been in your shoes. I know what it's like. If you've got 2 hours to talk to the jury, and that's your chance to try to persuade them, you're going to use all 2 hours. If you've got 3 hours, you're probably going to use all 3 hours. And the longer you go, the more the jury is going to hate you. So I'm doing you a favor. I think 2 hours is sufficient. Is anybody opposed to 2 hours?
Yeah, I do remember reading a story about Clarence Darrow where he took a whole week to do a closing argument in a murder trial. I think 2 hours is preferable, Your Honor, and we're okay with that.
But I could live with 2 hours.
Okay, why don't we plan for 2 hours per side? Ms. Brady?
Judge, are we taking July 17th off? That's a Friday.
Well, we were planning on it, but we can change that if, given the schedule that we're talking about right now, we could change that. So, but it depends, it depends on how long the jury deliberates. If the jury comes back with a verdict on the 14th, let's say, and then that's the end of the proceedings, and we don't have to worry about the 17th. If the jury comes back with a verdict on the 14th and we have to have a sentencing hearing, then I think we got to figure out at that point, what to do and what new schedule to put into place. We probably will have to have some kind of discussion if we have to have a sentencing hearing before we proceed in terms of what instructions I initially give the jury and that kind of thing. So we're probably going to have to give ourselves at least a half a day and maybe just a full day just to have those discussions. So it'll just depend. So right now it's marked as an off day,
Okay.
but I am flexible and I'm open to changing that.
And so I'll just tell the court my concern, and I know that there's probably nothing the court can do, but if we do closings on Monday, and if Mr. Orman's correct that the jury will take a long time simply given the amount of evidence that's been presented, I worry about bringing witnesses in as early as Wednesday. And so would the court prefer to have sentencing begin if we get there the following week and just make it that we're pretty certain they'll be at least have a verdict within that week? And then, because I don't know whether to schedule witnesses for the 17th, not knowing if it's a day off. But if we just gave the whole week of the 13th to deliberations and whatever legal matters the lawyers in the court need to do, and then start sentencing the following week, that's another option. And frankly, I mean, we can adjust. I just don't know what the best estimation is to start bringing in out-of-state witnesses.
In terms of a sentencing hearing, if we have to have one, how long are the people looking at in terms of phase one or step one?
Your Honor, I anticipate we've presented all the evidence we need for Phase 1 at this point to establish our aggravating factors. I think Phase 1 is going to be complete argument. I don't think there's going to be any evidence.
All right, what about phase 2 in terms of mitigation?
I am predicting probably 1 week, perhaps into the second week.
All right, and then it's hard for you to know what rebuttal you would have, but, what's your best estimate in terms of any rebuttal you might have in step 2?
Can I just think through that in my head for a sec, Your Honor? For a rebuttal, I would say a max of 3 or 4 days.
And then what about step 3, the final phase, in terms of victim impact evidence and other evidence that the parties may wish to introduce? And I know these are only rough estimates because it's difficult to predict way in advance.
I'm thinking that if we get to that phase for victim impact evidence, we're probably talking 3 to 4 days, maximum.
All right, and the defense might have other evidence in phase 3 as well, but any idea how many days?
No idea.
No idea, okay.
No.
Well, my preference would be to not have too long of a delay between the guilt phase and any additional proceedings that we have to have. But it's hard to estimate how long we're going to need because we don't know how long the jury is going to deliberate. In terms of the amount of evidence, it's true that there's a lot of evidence that has been introduced, but it's also true that the jury has been allowed to review it as we go. And so even though that has been taking time from the trial, I think in a way it has been saving time in terms of the jury being able to review the evidence now as it has been introduced. So, I don't know. I don't have any way of knowing how long deliberations are going to take. It could be a day. It could be 2 days. My preference would be to be ready to start on Thursday, the 16th of July, with the second part of the proceedings if it's necessary at all. That would be my preference. Do the people have a position on that?
That's our preference, Your Honor. One thing I would note about the 17th is I seem to recall in one of the jurors saying he had set some type of medical appointment for that date. I think that's the date he was talking about. I don't have any notes on that. But I agree with what Your Honor said. I have one other question, but it's not responsive, so I'll wait on that.
All right. If we have to take Friday off, then I think it just makes sense to set it on Monday and start on Monday, the 20th. So we'll ask the juror how solid whatever he or she has going on the 17th is and how important it is and whether it can be changed or not. But if it's a medical appointment that cannot be changed and we have to take Friday off, then I don't think it makes any sense to start on Thursday and run the risk that people are going to be waiting here anyway because we're not going to be ready to go.
I agree, Your Honor. One thing I would suggest, though, is we don't know what plans other jurors might have made for that day, knowing it was a day off. So we might need to ask all of them if they have any plans for that day.
All right, I'll do that. Any objection to me inquiring about that?
No?
Okay, I'll ask him. All right, Mr. Orman, what else? Wait, before you go, Mr. Orman, Ms. Brady, did you have anything else on scheduling?
A question about whether the court would allow us to give one opening statement at the very beginning of sentencing. And Your Honor, the reason we would like to do that is since, as the court knows, the sentencing trial is so different than the first trial, just to have an opportunity to review with them phase 1, phase 2, phase 3, that the information is now being presented for a different reason, and to do just one opening statement at the beginning of sentencing.
Well, it depends. And this may be part of the discussion that we have to have if there is a guilty verdict on a first-degree murder count. Because if I'm going to have introductory remarks, I'm anticipating that I would explain all that again, and I'm the one who's going to be telling them that. But if despite what I say to them or what we agree I should say to them to remind them about the process and to remind them about what things they can and cannot consider as we go through the process, assuming we get to a sentencing hearing. If you still want an opening statement at that point, then I wouldn't be opposed to it as long as both sides get an equal opportunity to an opening statement. But let's table that for now. I mean, if the purpose of the opening statement is just to explain the process and to explain what evidence the jury can consider at each stage, then it doesn't make sense to have it because I'm planning on covering that. But if you want an opening statement to address sort of what evidence you anticipate being presented and similar to an opening statement at the guilt phase of the trial, then we can talk about that. We can try to figure out if it makes sense to do that.
And I can let the court know we will ask for that, so if the court wants to consider that.
Okay. Do the people have a position on that, Mr. Orman?
We object, Your Honor, and here's why. The court has, for lack of a better word, trifurcated the sentencing proceedings, and the jurors are going to be asked to make individual decisions, and by individual, in some stages, they're actually individual. In the first stage, it's individual in the sense that it's only related to whether we've established aggravating factors. And as we discussed with them in jury selection, and as the court knows, and as the court has decided, these are independent decisions the jury makes in each phase. So what we would be having is someone saying, okay, here's what you're going to hear in phase 2 if you get to it. Here's what you're going to hear in phase 3 if you get to it. So what are we then going to be allowed to say? You're going to hear some really impactful victim impact evidence from these people, and this is what we expect you to hear in the third phase if we get to it. Well, how are we going to present that type of evidence in an opening statement when we don't know if the jury's going to reach that decision and when it's irrelevant for phase 1 and irrelevant for phase 2? So if the defense wants to do these opening statements, it can't be for the totality of the sentencing hearing. My position is that we should just have one sentencing hearing and the jury just makes all the decisions without trifurcating it. If we were doing that, it would make a lot more sense. But that's not the way we're doing it. So to me, making opening statements in such a fashion would lead to the presentation of irrelevant evidence for the individual phases. And because of that, I would object to it.
Okay. I think Mr. Orman raises some valid concerns, so I will think about it, but I think these are valid concerns. And you're going to have closing argument at the end of each phase, so you'll have an opportunity to argue, and it's preferable once the evidence, whatever evidence may have been admitted, has been admitted for you to argue about that as opposed to trying to predict in advance. And Mr. Orman is right. I have truncated the proceedings, again, assuming we even get to a sentencing hearing, but I think it's the safest way to go. I think that if you just do it all in one and say, here are the instructions, and we all know how complicated they are, and expect that they will go through the process on their own, I think that's asking for trouble. So I would prefer to do it in the truncated fashion that I have outlined, and even if that means taking a little more time and having sort of 3 mini proceedings, if you will, at the end of which each side gets closing arguments, I think that's preferable than to doing it without truncating the proceedings.
And I would ask the court to consider, in light of that, very short opening statements before phase 2 and then before phase 3. And I can tell the court, things that we would want to say to the jury that I don't know would fit into the court's instructions would be, you're going to hear things from his childhood friends, and the reason that evidence is presented to you is because you should have all the information about his life and background, and to remind them. Our fear is that they'll be hearing these things and thinking, why are we hearing that, and not realize the purpose for which some of this evidence is being presented. And I think that could be done very quickly before the beginning of the phase, and so I'd ask the court to consider that. And, Your Honor, if we can come up with some authority or something we want the court to consider, would the court allow us to present that to the court?
Orally, yes.
Okay.
Yes.
Thank you.
And if I may, Your Honor, one thing that I think is different that I think is a reason not to allow this is because one of the things the court has not required the defense to do, and I'm not quibbling with the court's decision, it's just the lay of the land that we have right now is they're not required to give us expert reports for the expert witnesses that they are presenting. They've given us some, and some they haven't, in the sentencing phase. So we would be in a position of possibly hearing for the first time in the defense opening statement of phase 2 especially, what that evidence is going to be. And who gets to go first in such an opening statement? Do we get to do an opening statement when we don't even know what the evidence is going to be because it's primarily the defense evidence and we present rebuttal? It would place us in an untenable and unfair position. So if the defense is going to be asking for that, we will be objecting to that.
Okay. All right, I will think about it. You've got an uphill battle, Ms. Brady, but I will hold off on making a ruling on that. I'm not convinced that it's necessary or that it's going to be all that helpful for anyone, and I think there are things that I'm going to be able to cover anyway in my instructions. I think it's better, to the extent that you want me to inform the jury about anything, I think it's better that we do it through the court's comments. And I can, I will be talking to the jury about what is going to be happening in general, and so if I'm going to be talking to them about mitigation, then they'll understand why evidence is being presented. And these are things that we've talked to them already at length in individual jury selection and in group jury selection to some extent, but especially in individual jury selection, individual voir dire. All of us spent a lot of time with each of these jurors in individual voir dire talking about the concept of mitigation and what kinds of things they can take into account, what kinds of things they may be instructed they have to consider, those types of issues. So I'm not too concerned about that, especially given that I'm planning on giving them instructions along the way. But I'll hold off on making a final decision on it, and I'll give you an opportunity to present authority orally, and then we'll go from there. All right, are the parties ready for the jury?
Can I have the court's indulgence for
Yes.
two more issues? One is I expect that victims will be contacting us inquiring of a couple of things. One is the 13th. Obviously, if we have some delays and we're still in an evidentiary presentation stage on the 13th, which I think is extremely unlikely, but as the court said, we thought it was unlikely that Dr. Metzger might miss his flight, if the victims are going to want to know if the 13th, other than that possibility, is a firm date and it's not going to be moved forward. And because I think some of them might want to make arrangements to fly into town. So they're going to hear that. So is that going to be, unless we're still doing other stuff, is that a firm date at this point?
I just said it.
Yeah, okay.
July 13th.
Thank you, Your Honor. I just wanted to seek clarification.
With the caveat, of course, that I don't control the proceedings. I have some control, but I can't predict everything. You folks have some control in terms of what evidence you're presenting and in terms of how long things are going to take. So, if we get to July 10th and you haven't finished your rebuttal, and you say, Judge, we need the 13th to finish our rebuttal, and your victims are saying that they're here for closings, what do you want me to do? There's not a whole lot I can do. Or if the defense gets to the 13th and they say, Judge, we thought we would be done by the 8th, but it's the 13th and we still have one more witness, I'm going to have to let them present that witness. So with that caveat that this is just our best estimate and that's the best we can do, yes, July 13th is the firm date for closing arguments.
Thank you, Your Honor. The last thing I have, and it's only because we're talking about all these scheduling things, is once deliberation starts and a jury comes back with a verdict, has the court given any thought to the amount of time it would give the parties and victims who might be in the area to get here to hear the verdict? I think that based on the number of victims here and how many people may be in town and how we would have to make phone calls to let them know to come in, we would request a 3-hour delay. And I know that's difficult on a jury to say you've reached a verdict, now wait 3 hours to deliver it. But I just wanted to raise that with the court, and I'm not asking for a decision now, but I'm telling the court that's what we're going to be requesting.
Okay, I have given that some thought, and I will allow some time for both sides to get folks that they want to get here. So if 3 hours is what you need, then, and 3 hours is what the defense needs, then 3 hours is what we'll take. And I get that it's an important case. I get that there are a lot of people involved, and I get that a lot of people want to be here. So if we get to that point and the parties are requesting 3 hours, I don't see a problem with it. And if the defense wants more than that, I'll go with it as long as it's reasonable. It can't be like 2 days or something, but 3 hours or something along those lines is fine. All right, anything else?
No, thank you.
Yes. Ready? Okay, let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Good morning, everyone. It's Friday. Yes, it is. Thank you for your patience this morning. We were having some discussions about scheduling, and I need to ask you if July 17th, which is a Friday we had been planning to take off, is still a Friday that we need to take off. And if it is, that's okay, but we're just trying to plan ahead. So at some point, let my staff know whether any of you has to take July 17th off. We're still ahead of schedule, so this is not an indication that we've fallen behind schedule. We're just trying to plan ahead and figuring out what the schedule is going to be like in the next couple of weeks or so. And so July 17th right now is a day that we have planned to take off, but if it's not a day that somebody needs to be off, then we might be able to work. And I think one of you has a medical appointment, 2 medical appointments on that day. So if that's the case, and those are medical appointments that you would rather attend and not have to reschedule, we will respect that and we will still take it off. So just let my staff know, please. All right? It's not a problem. Okay, at the end of the day yesterday, at the end of the day, there was a different witness, but before that, Dr. Woodcock was on the witness stand. And Doctor, I'll ask you to resume the witness stand. Sir, I remind you that you're still under oath. And Mr. Brockler, in a moment, you may proceed with the rest of your cross-examination of Dr. Woodcock. In the meantime, I want to remind the jury that the court has admitted the testimony of Dr. Woodcock for a limited purpose. You may consider this testimony only as to the issues raised by the defendant's plea of not guilty by reason of insanity. You shall not consider this evidence for any other purpose. Please remember, folks, that when I refer to the issues raised by the defendant's plea of not guilty by reason of insanity, I mean issues related to 2 questions. 1, whether the defendant was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act. And number 2, whether the defendant suffered from a condition of mind caused by a mental disease or defect that prevented him from forming a culpable mental state that is an element of a crime charged. All right, with that, Mr. Brockler, you may proceed.
Thank you, Your Honor. Good morning, Doctor.
Good morning.
There were just a few areas I wanted to finish up with on July the 24th before we move forward with the rest of your evaluation of the defendant for sanity, okay?
Certainly.
One of the things that was prominent both in your notes and your discussion yesterday was the fact that the defendant had substituted thoughts of killing others for thoughts of killing himself, for feeling suicidal. Do you recall that?
Yes.
And based upon your discussion yesterday and the notes that you provided, that was a conscious decision by the defendant to substitute homicidal ideation for suicidal ideation. Fair?
Well, first of all, it was something, I wouldn't characterize it that way. I don't think it's something that he planned. I think it's something that he really discovered.
But he was aware that he was substituting thoughts of harming others for thoughts of harming himself. You'd agree with that?
Yes, I would agree with that.
And he'd been aware of that for a very, very long time.
Yes.
This was not something that was working in the background that he wasn't aware of, that he just concluded on his own was occurring. This was something he was consciously aware of.
Yes.
Okay.
It was a strategy he had practiced.
Right. And that was true throughout, from about middle school, you'd say, all the way through when he sat down with you on July 24th?
That's what he reported. He didn't report it to me on July 24th, but he did in my later interview, and it was reported in the interviews of the other people.
Did you say he didn't tell you on July 24th that he had substituted harming others for harming himself?
Yes, I don't believe he got into that detail.
Can you look at page 7 of your notes, Doctor?
Yes.
I don't know, a quarter of the way down, there's a phrase that you attribute to him that says, they were a redirection from suicidal thoughts. He decided not to do suicide, he would do homicide.
Yes, we talked about those relationships. I think that I guess maybe I'm referring to how this was expressed at different times.
Well, fair to say on the 24th of July, 4 days after this happened, he's telling you that his decision in part to harm people was an effort to not harm himself based on these statements, right?
Yes, it was a way to deal with his suicidal thoughts.
Right, and he was consciously aware of those suicidal thoughts.
Yes, they were thoughts.
And they were thoughts that he'd been having since, according to this, high school and before, correct?
Yes.
Now, I want you to do me a favor because you've had the opportunity after the 24th of July 2012 to look at all of the discovery as you thought relevant, and I want you to tell us, prior to him sitting in that jail cell with you 4 days after the events at Century 16, did he ever tell anyone that he was suicidal?
I don't know specifically. I'd have to review my notes on the Dr. Fenton's and Dr. Feinstein's records, whether that was part of the violence that he talked about.
You can take a look at your records, Doctor. If you don't mind, though, I'd like to add, if you don't remember, you just tell me you don't remember, we'll go to the records. You recall from reviewing those notes that he denied being suicidal to Miss Roth when he first came in to see her on March the 16th, 2012. You recall that?
I'd have to look at those notes.
Okay, go ahead and take a look at those notes then and let us know if you recall that.
My summary in my March 26, 2015 note doesn't refer to that. It just refers to homicidal ideation. I don't have a copy of her notes with me.
Let me ask you this. You don't disagree with me then? You don't have an independent recollection that he told Miss Roth that he had been suicidal, fair?
I don't have a recollection one way or the other.
Does it remind you of those reports to know that she also asked him if he had ever made any suicidal gestures, and he said no? You recall that?
I don't recall that specifically.
Do you recall Dr. Fenton asking him on more than one occasion if he felt suicidal, and on every occasion the defendant saying no? You recall that?
I don't have an independent recollection of that.
You don't deny that that would have been in there, right?
I would expect that she would have asked those things.
Well, how about this? If you had found evidence that he had told anyone in the record that he had been suicidal prior to your meeting, you would have ended up documenting that either in that July 24th thing if you knew about it, and you probably wouldn't, or in your later report that you generated. You'd have documented that, right?
If I'd come across that, I think I would have.
So the absence of any documentation in your records about him ever having told anyone that he was suicidal before sitting in that jail cell with you 4 days after this event, you'd accept that there's nothing in the record where he ever indicated he tried to harm himself before.
Well, there was one significant early record, and that's when he did the action with the cardboard and cutting his wrists.
And where's that in the record? Do you remember who generated that memory?
My records from the Family Services in 1996 and Psych Care in 2002, my brief summaries didn't note that specifically. I believe that he had told me about that in the July 24th, 2012 report when he was talking about his treatment with Dr. Fenton.
The only record of that event was from the defendant on July the 24th, 2012 and after. Isn't that right?
That may be. It was if it occurred, then it would have been, of course, a historical note of prior suicidal ideation.
And it wasn't in the Salinas Family Services report of 96, right?
I didn't note it.
And you would have.
Yes.
And it wasn't in any of the reports from Mel Lipsey, and you'd have noted that.
Yes.
It wasn't in any conversation he ever had with Dr. Fenton or Dr. Feinstein or Mrs. Roth, because you'd have documented that too, right?
I think I would have.
So to be clear, the first time this I'm suicidal, and in the past I tried to use cardboard with some action on my wrist, the first time that comes up is 4 days after Century 16. Fair?
That may be.
Do you disagree?
I don't know if there was ever any evidence. I don't have any evidence that it occurred before.
Let's just quickly go through a list of other people he never told that to. His girlfriend, Miss Dada, do you remember record about her?
Yes.
Remember reading? And you remember, in fact, she's the one that he starts to have this G-chat with, this Gmail chat with, I think based on your statements, trying to recruit her into thinking about his philosophy of killing people. You recall that?
Yes.
Pretty personal detail. You'd agree?
In terms of whether he mentioned suicide?
Well, pretty trusting of him and personal for him to reveal to her that he's having to kill people, right?
Yes. Yes.
He never, ever tells her in any document you can find that he was suicidal, right?
That's correct.
He never tells Ben Garcia he was suicidal, right?
Yes.
And we'll get to the emails more later, but you would agree that the dominant form of communication between the defendant and his parents were emails, not phone and not in person over the year before this shooting, right?
I think that's correct.
And nowhere in any of those emails is there a suggestion anywhere that he is suicidal. Fair?
Yes.
One of the other things that you talked to him about during the course of your conversation, and we'll get to the point about you having to evaluate whether he knew right from wrong and capacity and all that other stuff. But one of the things that you elicited from him was a discussion about the fact that the prosecutors in this case were seeking justice for those, and the word that he used was wronged. Do you remember that? Those who were wronged. And sir, I'm sorry, Doctor, page 13, very close to the bottom.
Yes, I asked him what...
Wait, hold on.
I'm sorry.
Just to answer the question, it was a yes or no question, right?
Yes,
Mr.
sir,
Buckler?
that's right.
All right, so is the answer yes?
Can you repeat the question?
Yes, sir. When talking about specifically, in this case, the defendant said that the prosecutors were seeking justice for those, and the word that I'm emphasizing here is the one you wrote down, wronged. That's correct, right?
Yes.
And that's the word he chose, correct?
Yes.
Now, at the conclusion of that July 24th, 2012 meeting, you had now these 14 pages of handwritten notes, correct?
Yes,
And they included on that last page, as we discussed yesterday, a series of impressions or potential differential diagnoses, correct?
yes,
And you thought that this guy really needed to be on antipsychotic meds.
yes.
So I want to ask you about someone named Erwin Mosier. Tell us who Erwin Mosier is.
He's a psychiatrist, and that I learned that day that he was the psychiatrist at the jail.
In fact, he comes to you after your meeting and lets you know a couple things that are significant to whatever medications the defendant is or isn't on. Fair?
Yes,
One of the things he tells you is, hey, look, the public defender's office has said I can't go in and talk to this guy unless they give me permission, and you've been able to do it. Do you recall that conversation?
yes, I recall that conversation.
And so he said to you, I'm relying upon you, doctor, to tell me what the appropriate medications are, if any, because we haven't seen it yet. If this guy needs to be on meds, please tell me what you think is appropriate. Do you remember that?
We had a discussion about my impressions. The implication that I was somehow or other recommending treatment specifically in a treatment capacity is not part of that conversation.
I understand. He told you that he wanted to, because you were the only one that had been allowed to talk to him, he wanted to have you tell him your thoughts, impressions, and what your recommendations were for him to consider. Isn't that fair?
Yes, that's fair.
And you said, well, you know what, I'm going to come back on the 30th of July. Let's talk about it more then. Correct?
No.
You told him you needed to get clearance from the public defender's office about whether or not you could even give him that information.
As I recall, no. I told him what my impression was, and based on my impression of psychosis, of severe psychosis, that antipsychotics would be appropriate.
And you had agreements to have further conversations about that, correct?
I don't recall specifically. I know that I made it clear that I was not in a treatment relationship at that time, and that with Mr. Holmes, and I never made any arrangements or commitments to follow up in communication.
You had the opportunity, after the 24th, of course, to review the notes of Dr. Mosier, correct?
Yes.
Yeah. And if you took issue with any of those notes, you'd certainly let us know.
I took issue with those notes. I didn't specifically bring it up to anyone.
Let me read to you a couple of things that you're familiar with, and you tell me if you agree or disagree. This is from Dr. Mosier, July 26th. Dr. Woodcock will apprise me of his opinions of patients' need for psychotropic medications, if any, and we will discuss this before I prescribe. True or false?
That's not what happened to my recollection. I think it was a misunderstanding. When I first read that, several years after the July 2012 interview.
It's more than that, isn't it, Doctor? Because he ends up calling you several times and leaving you messages to call him back. Do you remember that?
Yes, I do.
And you did not return those calls.
When I received the first one of those calls, I contacted Mr. King, and he told me to hold off.
So that we're clear, a doctor who told you he was going to wait to prescribe to hear from you calls you multiple times, and you didn't call him back because Dan King told you not to.
I do not recall that Dr. Moser ever told me he was going to hold off. I was not the treating physician. Dr. Moser, in my understanding, was the psychiatrist at the jail. I had made it clear to Dr. Moser that I was not in a treatment capacity. When Dr. Moser and I spoke after my interview, I shared with him my diagnostic impressions. Those diagnostic impressions, I worked with Dr. Moser before. He's an excellent psychiatrist. He knew what the implications of those were. We had a brief discussion about antipsychotics. I was not in a position to prescribe or to tell Dr. Moser what to do. Dr. Moser did contact me, and based on that, those conversations and my understanding of the treatment responsibilities, no, I didn't get back to him. I was not in a treatment relationship.
And you know that he was contacting you to get your advice, input, and clearance to prescribe. That's what he told you on those messages. Call me back about this guy, right?
That's correct.
And even if you weren't in a treatment relationship, one thing we know you didn't do was to call him back and say, I'm not in a treatment relationship. Go ahead and do what you think is best. You never made that call, did you?
I did not make that call.
Doctor, you in your experience, you familiar with the idea that a strategy might be to allow someone who may have mental illness to go unmedicated in a setting like a jail, to allow that mental illness to manifest itself in a more dramatic way?
Objection, Judge. May we approach?
Yes. All right, the objection is sustained.
Doctor, you were contacted, according to your testimony, some 2 years after this 2 hour and 45-minute visit with the defendant. Is that accurate?
I'm sorry. Can you repeat the question?
Yes, sir. You were contacted some 2 years after your 2 hour and 45-minute with the defendant on July 24th, 2012?
Yes.
And by contacted, I mean by the public defender's office?
Yes.
In that ensuing time, that intervening time, you had turned over your 14 pages of handwritten notes, correct?
I believe so, yes.
Did you inquire about whether or not you should generate a report?
Yes,
And they told you, no, please don't generate a report.
that's correct.
And so you didn't.
That's right.
Did you do any other thing regarding this case before the public defender contacted you again 2 years later?
I don't believe so.
You remember when 2 years later they contacted you? What I'm trying to get a sense of is was it like, 2 years from July? Was it August, September? Where in the process of 2014 were you finally contacted?
I think it was in early summer 2014.
July, August I'm sorry, June, July, is that fair?
About then, yes.
Okay, and when they contacted you, what they told you was, Doctor, we would like you to now do a full-on psychiatric evaluation of this defendant so we can get your opinion on his sanity.
Objection, Your Honor. Calls for speculation, lack of foundation.
Overruled.
Go ahead, sir.
No, they asked me to review a lot of records and see what my impression was based on those records.
They asked you to review records, and based on your review of records, come up with an opinion of sanity?
To give them my impression of, based on my initial interview and then very extensive records regarding the crime and the treatment that he'd received and past medical records, and give them my impression at that point.
Well-
So they weren't asking for a final formal evaluation or report.
What month and year did they tell you they were going to ask you to come into this room and give an expert opinion about whether or not that guy was sane?
I believe that was earlier this year.
Earlier this year?
Yes,
Was that after you had given them your impressions?
yes,
And did you give them your impressions in a written format,
no.
just over the phone?
I don't know if it was over the phone or if it was in a meeting. But
And
it
so
one or the
was it,
other.
forgive me, January, February, or March of this year when they told you, we would now like you to opine on his sanity?
It was in that time frame.
But you don't remember which month?
No, I haven't reviewed those details of my records. I know that it resulted in the reports that are dated March 26th and April 1st, so I was working on those in the early part of the year.
Were you working on them in the early part of the year in response to them telling you they wanted to make you an opinion expert on sanity?
Yes,
Okay. And by the way, that report is the first report you generated in this case, very first, was 3 months ago today. Is that fair?
yes,
March 26, 2015, correct?
yes,
They had told you earlier in the summer, 2014, to review things and give you their impressions, but certainly by March 26th, you knew you were going to be asked to put your expertise behind an opinion about whether or not this guy had the capacity to know right from wrong based on societal standards of morality and the capacity to form the intent to murder after deliberation. You knew all that, right?
yes,
That's a very important and serious thing in your opinion, isn't it?
yes,
And in fact, one of the things that you would want to make sure you do before you render such an opinion is carefully and thoroughly review relevant medical and scientific data before offering that opinion, right?
yes,
And if you thought that the information that had been provided was incomplete or inaccurate, you would request additional information or clarification from the attorneys on that side of the case or other relevant parties before you even agree to render an opinion, correct?
I would want to make sure that I had sufficient information to render an opinion. And I felt that I had that based on the records I'd reviewed.
I'm going to go back and ask you if you agree or disagree with this sentence. If an expert believes that information that has been provided is incomplete or inaccurate, the expert should request additional information or clarification from attorneys or other relevant parties before agreeing to render an opinion.
I think that's what I said, that I would want it to be sufficient to reach that opinion, and I'd reviewed records, and I felt it met that criteria.
We'll get there, Doctor, but you agree with that sentence, right?
Yes,
And that sentence, as you know, comes from a couple places. One is the American Academy of Neurology Qualifications and Guidelines for the Physician Expert Witness, correct?
you presented a copy of that yesterday.
Do you want to see it again to confirm that that's what you're agreeing to?
I agree with the statement.
Okay. It's more than that, though. It's not just that you agree with the statement. You actually cite that rule in an article that you wrote. Do you remember that?
Yes.
What was the nature of that article?
It was a review for neurologists of medical legal practice.
And you give
or
them
medical
certain...
legal consultation in neurologic practice.
Yes, I'm sorry to have interrupted you. And part of that article was you giving them advice on how to effectively testify, correct?
Yes.
And included in that recommendation is that when they're testifying, they should think of themselves as a teacher and the jury as the learners. The consultant should address them, maintaining good eye contact, and not the attorney asking the question. Is that fair?
That's correct.
In fact, you also gave further advice that may be helpful for consultants. I presume you mean expert witnesses. Is that fair?
Yes.
To imagine themselves doing their best to establish rapport and trust with an anxious new patient and family in their practice. Is that fair?
Yes.
And that's part of the article where you cite back to this rule that says you're not even going to agree to give an opinion unless you think you're going to have access to all the information you think is important, correct?
Judge, I think that's a misstatement of the opinion.
Overruled.
Do you agree with that, Doctor?
I agree with that.
One of the things that you would have wanted is the opportunity to go back into that jail cell or wherever and talk to the defendant again, correct?
Yes.
And you did that, right?
Yes.
You asked the public defender's office for the opportunity to go in and interview him about all the issues you thought were relevant to help you make an opinion on sanity.
To confirm my opinion, yes.
To confirm your opinion,
Yes.
not to help make your opinion?
No, I had reached an opinion based upon my initial interview and the review of the records.
Your interview from several years before for 2 hours and 45 minutes where you weren't allowed to talk about the crime or the preparation for the crime, that interview?
That's correct. That was part of the information that I had in reaching my conclusion about sanity.
And we'll get to the rest of what you covered in just a moment. I want to stay on this interview that you had the opportunity to get. Now, in no way did the public defender's office tell you you may not talk with him until you've rendered your opinion about sanity. Is that fair?
That's correct.
You made the decision to render the opinion and then go see him in jail. Is that correct?
That's correct.
And to be clear, that March 26th date on that report, that's not a draft report or a, oops, I put the wrong date on it. That's really the date that you generated that report.
That's the date I completed that report, yes.
The public defender's office put no limitations on how long you could meet with the defendant to explore any issues you thought relevant to your opinion. Fair?
That's correct.
They didn't tell you the subject matter you had to limit yourself to in talking with him. Correct?
That's correct.
So, with that kind of freedom to make a decision about how long the interview would be, when the interview would be, and what the interview was about, you chose to interview the defendant 5 days after you issued an opinion on his sanity and for 1 hour. Is that fair?
That's correct.
And is it also accurate to say that in that 1 hour, 5 days after you determined he was insane, you again never explored with him the preparation for the crime and the actual crime itself?
That's correct.
Okay. Let's go to March 26th report, the one 5 days before that, and we'll get to the interview. One of the things that you did in your report, and you've already corrected this, and I appreciate that, you started off by listing all of the things that you wanted someone who's going to read this report to know that you considered in making your opinion. Is that accurate? And by things, I mean documents, discovery, that kind of stuff. I don't mean psychiatric treatises or the DSM. I don't mean that. I mean, in terms of the information that you considered from this case in making your opinion, you go through some detail in listing it out here. Is that fair?
Yes.
And that's important because you know that this report that was generated is going to be considered not only by the attorneys who hired you, but possibly by the prosecutors, correct?
Yes.
Maybe the court, correct?
Yes.
And in fact, as we've seen, maybe even this jury, correct?
Yes.
So it was important to be thorough and detailed, wasn't it?
Yes.
On this first page of your 13-page report, you start off by talking about your examination, and I appreciate you corrected it that it's really 2 hours and 45 minutes, not 2 hours. You then went...
I'm sorry.
Sorry?
No. Yes, you're correct. On the interview on July 24th, 2012 was 2 hours, 45 minutes.
Yeah, and thank you for correcting that. That's examination. The next thing you list is Holmes documents/evidence. Do you see that?
Yes.
And under that, you've listed photos of Mr. Holmes' notebook, right?
Yes.
And you described that as this included philosophical ramblings, correct?
Yes,
It also included plans regarding alternative homicide methods and places to choose, including details of theater. Right?
yes,
Then you list copies and transcripts of Mr. Holmes' jail writings. These were mostly philosophical ramblings, correct?
yes,
There is nothing else you list under Holmes documents evidence, correct?
correct.
And maybe we'll get to it at one of the other things that you listed here. Oh heck, we'll go through the rest and then we'll come back to it. The next thing you list are medical records. Do you see that?
Yes,
And the first thing that you list is a social history provided to you by the public defender.
yes,
And the things that you detail down below there are things that only came from the public defender, correct? Family history of schizophrenia and father's twin sister, psychotic. You didn't get that from the defendant. You've already told us that.
well, I think it was included in other expert reports.
Okay, but originally it only came from the public defender's office. You'd agree with that?
I don't know who came up with it first.
Did you list those under medical records as opposed to listing them under information you got from expert reports, which you do later on here?
Did I list what?
Well, so you listed this family history of schizophrenia and the father's twin. That sounds like that's a medical record you considered. You didn't include that under your list of forensic reports or information gleaned from the forensic reports. Is that fair?
I listed it here under the
Okay.
under the family history, the social history. Yes,
You also listed the mental health records from CU Anschutz, correct?
yes,
You listed Arapahoe County jail records, and I don't understand what this symbol means, sir, but you have P275FF references to Dr. Mosier contacts with me. What does that mean?
page 275 and following.
Are those the only Arapahoe County jail records you considered?
The ones following 275?
Right, the ones underneath Arapahoe County jail records, you list page 275. Are there any other Arapahoe County jail records you considered?
Well, I considered all the ones I'd been presented.
Okay, and had you been presented with all of them, like all of his conduct up between the time he was taken to Arapahoe County Jail in November and beyond?
I believe I had seen all the ones from the time he went into the jail until close to the time I had received them.
You also considered the Denver health records between November 15th and 20th, 2012, correct?
Yes,
And then on the next page, page 2 of the 13-page report, did I say? 13-page report. You go with clinical test results, correct?
yes,
And you list the testing done by Dr. Robert Hanlon.
yes,
Yes, and the dates of that testing are April 18th to 20th, 2013, right?
yes.
You did not consider the testing that he did in 2014.
If I didn't list that, then I assume I didn't see it.
Did you even know he'd been tested again by Dr. Hanlon in 2014? Before right now?
I don't recall. I don't think so.
If you had been provided that information, you would have considered it?
Yes,
You have some records here from CMHIP Dr. Thomas Gray, correct?
yes,
And you have his testing, or I'm sorry, interview worksheet of August 12th, 2013, correct?
yes,
You did not consider or include in your assessment the testing that was done in 2014 by Dr. Gray?
I don't have that date, that report dated, so I don't know that. the
Is
answer
it
to that.
accurate, Doctor, that as you sit here right now, this is the first time you've heard that there was additional testing done in 2014?
I don't have dates down for Dr. Gray's testing, so I don't know. I can't tell from this summary what reports I reviewed.
Do you have any recollection of him doing 2 sets of tests, just like Dr. Hanlon?
I don't recall one way or the other.
Had you had that information, you'd have documented it in here?
Well, I didn't document the date, which I should have done, so
Well,
I certainly would have tried to do that.
Doctor, you actually did document the date, right? On Dr. Hanlon, you documented testing 4/18 to 2013.
I'm talking about Dr. Gray's report. The only date I have there is for the interview worksheet.
Okay. Same thing with Dr. Manguso. You don't have anything that Dr. Manguso did in 2014?
I don't believe so.
Judge, may we approach?
Yes. All right, I'll sustain the objection as to the form of the question. You may rephrase the question, please.
Dr. Woodcock, are you aware whether or not Dr. Manguso conducted any additional testing in 2014 like Drs. Gray and Hanlon did?
No.
Mr. Brockler, I think we're getting some feedback from your microphone when you stand right next to the microphone that's under the podium. So I don't know if maybe you can turn it or something. Or just give it to Mr. Orman and have him hold it.
Thank you. Still there.
Still doing it. There you go, that's better. Thank you.
Sorry, I'm sorry, Doctor. I sort of lost my place for a moment. Top of page 3 of your report, you also list earlier medical records, and you agree with that, right?
Yes.
And you listed those Mel Lipsy records we talked about, fair?
Yes.
And the Salinas Family Services Center records, correct?
Yes.
And that includes back even in 96, they wrote down that he had oppositional defiant disorder.
Yes.
Okay. And then you went through the forensic reports that you had the opportunity to review, correct?
Yes.
That includes reports from Dr. Mahandi, yes?
Yes.
Dr. Metzner, correct?
Yes.
That's interesting there because it says there were videos of falls, and we may have seen one here in court yesterday. You couldn't open those or view those.
Not at that time, no.
Did you do it later?
Mr. King had a meeting and was with me and was able to get into those files and showed me those files.
When was that?
Earlier in 2015, I believe.
Before or after your report of March 26th?
After.
You got to see the video after you opined on his sanity?
I believe so.
Okay. And then you reviewed a report of Dr. Philip Resnick?
Yes.
Doctor, help me here. Go through And then it looks like you looked at, or I'm sorry, you considered the report of Dr. William Reed. Is that fair?
Yes, that's also listed.
Is that on page 8?
Yes.
And that is the last thing you list before you get into your impression of the defendant and your analysis of his sanity, correct?
Yes.
What is not listed on here is that you watched 22 hours of videotaped questioning by Dr. Reed of the defendant, correct?
That's correct.
Because you didn't watch 22 hours of videotaped interview by Dr. Reed of the defendant.
That's correct.
Do you know whether or not in that 22 hours the doctor spent a significant portion of time discussing in detail not only the defendant's motivations for committing this crime, but the actual preparation and the crime itself?
Yes,
fair?
I read Dr. Reed's report and I read part of the transcript.
You'd agree that that is the only recorded interview done by a psychiatrist, and in this case a forensic psychiatrist, of this event. You'd agree with that, right?
Of this event?
Yeah, in this case.
Yes, it was the only recorded interview.
Instead, you relied upon in making your opinion, because we don't get to the hour for 5 days, you relied upon your 2 hours and 45 minutes of interview with him 4 days after the event, correct?
That was one of the things I relied on.
Right. That's the only time that you actually got to observe the defendant answering questions, correct?
And the part of the Reed videos that I watched.
Oh, you watched part of them?
Yes.
How did you know which parts to watch?
I looked at the transcript some, but basically I watched possibly a half an hour of different parts, principally to observe Mr. Holmes' demeanor.
A half an hour of each of the DVDs?
No,
A half an hour of the total 22 hours?
that's correct.
Doctor, would it be accurate to say that if somebody, let's say people in this room, watched 22 hours of those videotape statements, they would have had a longer, greater period of time to observe the defendant answering questions about this case and his mental health than you did?
They would have observed him, yeah, at the time those interviews were done.
And that must mean you read through the entire transcript.
No, I didn't read the entire transcript.
How much of the transcript did you read?
About 100 pages.
And this was a transcript that was over 650 pages long?
I think it was, I don't remember how many pages, I think it was 2 or 3 binders.
How did you know which 100 pages to choose to read?
I think I read the first 100 pages.
You read the first 100 pages and then that's it?
That's all, yes.
And which 30 minutes of the 22 hours did you watch?
It was different segments throughout. I spent about a half an hour looking at different segments of it.
Well, based on your prior testimony that you used the transcript to guide you to what to watch on video, is it fair to conclude that you watched nothing past the first 100 pages?
I don't recall. I don't think I did it that systematically. I was basically sampling the video.
Judge, I do not know where that's coming from.
We'll try to address it during the break. Maybe it needs new batteries or something. It might be that it needs new batteries.
No, I've never. Doctor, to be clear, when you're asked to opine on someone's sanity, especially on this, the thing that you're trying to figure out is what was the defendant's mind in terms of capacity for the things we've talked about on July 19th and 20th, 2012, correct?
That's right.
Not what it was on July 24th when you saw him, right?
That's correct.
Not what it is today, right?
That's correct.
Or any time in between, correct?
That's correct.
And so in part in doing that, the things that you want to do are really to drill down on any statements that he made at or just before or after the time of this crime, correct?
Certainly information about the time of the crime would be most relevant.
Here are the collateral records. I want to ask you if you agree that you should consider in a sanity evaluation. The defendant's account of the crime to police or other witnesses.
Yes?
Now, to be clear, in your list of things you considered, you do not include the audio-taped conversation between Detective Apple and the defendant about the bombs in his apartment.
I did not include that. I'm quite certain that I reviewed it. It's not included in my list, but I looked at a great deal of the law enforcement records. I did not include that in my list here. I believe that was referenced and included in some of the other forensic reports that I looked at. They were quite extensive and included a lot of that information.
You're talking about other doctors listened to it and referred to it, and that's what you relied upon?
I think some of those files included the originals, but that was part of the review that I did in 2014. I know I reviewed several thousand pages of records at that time, including law enforcement records.
Was it a video recording, an audio recording, or a written report, Doctor?
I think that they were written reports. I don't remember audio recordings, although there may have been a transcript of those.
Okay. He also provides an account of the crime to Dr. Reed in that video, doesn't he?
Yes,
Fair to say you did not watch it.
I believe that's correct.
In fact, the other thing you'd agree upon as a collateral record to consider in a sanity evaluation are audio and videotaped statements from the defendant, right?
Yes.
And that includes the videos to Dr. Reed, right?
Potentially. I chose not to take the time to do those.
I know. Witness and victim statements, you would consider all of those?
I think I reviewed a lot of those in the 2014 review of several thousand pages. There were a lot of victim statements in that material.
And other witnesses too, correct?
I believe so, yes.
Including all of the CU professors?
Yes, I reviewed the material from them.
And Ms. Dada?
Yes,
And Hillary Allen?
I believe so, yes.
And to be clear, you don't make any reference in your report in terms of the things that you evaluated to the text messages between Ms. Allen and the defendant?
I believe that they were included. They were omitted. That review was omitted from my report.
Well, hang on. Not only did you not list those texts as something you considered, but you omitted considering them in your report? Is that right?
I didn't discuss them in my report.
Did you watch the videotape of the crime scene?
I believe I did. I think that was yes, that was included in the law enforcement video.
That's the kind of thing that's going to stick out in your mind, isn't it, Doctor?
Yes.
So you do remember watching it, or you don't know if you watched it?
It was included in the, I watched a long law enforcement video on this.
And Doctor, I'm just trying to get to an answer on this. I know it was included. You've said that. Do you have a memory of watching the video of the crime scene in the theater?
Objection, asked and answered.
Overrule. It's been asked. It hasn't been answered.
Go ahead, sir.
Yes.
You did watch it.
Yes.
And you watched the video of the apartment with all the bombs set up?
Yes.
You have watched, or you have reviewed all of the jail booking and treatment records following his arrest?
Yes.
And we already know the answer to this one. You haven't considered all of the prior psychological testing because it sounds like you weren't aware that there was some done in 2014. Is that fair?
Yes.
You're also going to consider any writings from the defendant that may reflect his or her mental state or motive, correct?
Yes,
That would include the notebook, right?
yes,
And we know that you had the notebook, correct?
yes.
You sat down 5 days after you opined that the defendant was insane. You sat down and went through the notebook in some detail with the defendant.
No, I don't think I ever said that.
That's right. In fact, you never reviewed the notebook with the defendant, did you?
That's correct.
One of the other things that you could consider, for a couple different reasons, and we'll talk about them, are the electronic communications of the defendant leading up to this crime. You'd agree with that, right?
Yes,
And there's a couple reasons that that's important. One of them being that when we talk about disorganized thinking or disorganization as a result of mental illness, where we see it impact folks is in their communication. You'd agree with that?
sometimes we do, sometimes we don't.
Right. But we can't know till we look, right?
That's true.
May I approach Your Honor over here?
Yes. And Mr. Bruckler, when you reach a point where it makes sense to take our morning break, let me know and we'll do that.
We can do it now if you'd like, Judge.
Okay, let's do that.
Yes, sir.
All right, members of the jury, let's go ahead and take our morning break. Please keep in mind all my admonitions during the break. They all apply. I'll see you back here a little bit after 10:30, about 10:33 or so. Thank you. Please be seated, everyone. The record should reflect that the jury has exited the courtroom. Let's go ahead and take our morning break, and I'll see you folks in 20 minutes. The court will be in recess.
Please rise.